Hello, everyone. I need you to take a breath and stay with me for a moment. What I'm about to explain isn't loud, it isn't explosive, but it challenges how many people think courtroom moments actually work. Donald Trump was present. Yes, but this story isn't about personalities or politics. It's about process, about timing, about what entered the record first and what happened immediately after. If you believe that courts matter more than viral clips, if you value steady explanation over outrage, I hope you'll take a moment to like this video, share it with someone who still believes the rule of law deserves attention, and subscribe so we can keep having conversations like this. Because institutions don't collapse all at once, they change quietly and only if we stop paying attention. Here's what most people miss. Courts do not respond to emotion the way audiences do. Judges aren't listening for volume. They're listening for sequence. What was said, when it was said, and what reaction followed not emotionally, but procedurally. Inside a courtroom, emotion is never the conclusion. It's a signal. Judges are trained to read those signals the way doctors read vital signs calmly, without drama, without assumption. They don't ask whether a reaction feels understandable. They ask why it appeared at that exact moment. Timing in law often tells a deeper story than words ever could. An outburst, a visible strain, a sudden shift, none of these are evaluated in isolation. They're measured against what came immediately before. What question was asked? What answer entered the record? Whether something new and uncomfortable had just become permanent, I've seen cases change direction without anyone raising their voice. A single sworn answer, a pause, a reaction that arrived just a second too fast. And when that happens, the law doesn't rush. It absorbs. It remembers. The witness in this moment didn't dramatize anything. They didn't accuse. They simply answered a question. And once testimony is given under oath, it no longer belongs to the person who said it. It belongs to the court. That's when everything changes. Because from that moment forward, the case stops being about strategy and starts becoming about consequences. Many people focus on what they can see, the frustration, the tension, the reaction. But courts don't work on instinct. They work on reliability. Judges care less about how someone reacts than about what triggered that reaction. Emotion inside a courtroom raises questions, not conclusions. Questions about preparation, about control, about whether the ground just shifted unexpectedly. And that brings us to the witness. This wasn't background testimony. This wasn't filler. From the moment the witness was sworn in, the room changed. Judges feel that. Experienced attorneys feel it too. What made this moment matter wasn't drama, it was precision. The witness didn't speculate. They didn't offer opinion. They introduced a detail that had not been clearly established before. That's what courts are built for, not spectacle clarity. Public statements can evolve. Arguments can be reframed. Opinions can shift. Sworn testimony does not. Once it's on the record, the court is obligated to reckon with it, whether anyone likes it or not. Judges begin comparing immediately. Testimony against documents. Statements against timelines. Words against prior filings. When something doesn't align, the court doesn't ask whether someone meant to mislead. It asks whether the record now contains competing versions of reality and how that conflict must be resolved. And here's the part most people never see. There was no dramatic interruption. No gavel strike. No speech from the bench. Instead, there was a pause. Not uncertainty control. The judge slowed the room. Questions became more deliberate. The tempo changed. That's how authority works in courtrooms. It doesn't announce itself. It settles in. Silence in a courtroom is never empty. It signals attention. It signals evaluation. From that point forward, every question was filtered through what had just entered the record. This is where experienced observers lean in, not because something explosive happened, but because something subtle did. Courts don't think in moments. They think in patterns. A visible strain here. A contradiction there. A reaction under pressure. Individually, they seem small. Together, they form a story the court cannot ignore. This isn't about blame. It's about manageability. Can the case proceed cleanly? Can testimony be reconciled? Can the record support a ruling that will hold up later? Once reassessment begins, it doesn't stop at the end of the day. It follows the case forward, quietly influencing scrutiny, patience, and enforcement of rules. For many watching, especially those who've relied on courts to resolve property, finances, or family matters, this matters deeply. You don't want drama from the law. You want steadiness. Courts exist to slow uncertainty, not accelerate it. To filter pressure through procedure and precedent, that's why restraint matters. The Constitution doesn't assert itself through volume. It asserts itself through structure. No one, regardless of position, operates outside the same rules. Moments like this don't decide outcomes. They shape context. They become part of the record revisited long after cameras leave. And that's why accountability in law is rarely loud. It unfolds slowly, through transcripts, through patterns, through time. If you value conversations like this, grounded, careful, and steady, I hope you'll stay with us. Like this video, share it with someone who still believes the rule of law matters. Subscribe so we can keep making sense of these moments together. Because the most consequential actions in court are often the least visible. A pause, a note taken without comment, a pattern recognized but not announced. Those are the moments that shape outcomes long after the noise fades. Stay curious, stay steady, and stay engaged.